Hello, I'm Annette, founder and principal of Lakey Family Law. If you're newly separated or even just contemplating separation, chances are you are grappling with lots of questions about how things may work or play out, not at least of which are likely to relate to your financial position and your kids. Which is why I thought I would use this video as an opportunity to explain a little bit about how family law works when it comes to the division of property and assets, parenting arrangements and child support. Now, when it comes to working out who gets what, in Australia, the family law system works off the concept of the property pool, which is basically the total value of all your assets, less any debts. It includes everything you own or owe, individually or as a couple, including things like the family home, investment properties, savings, superannuation, investment portfolios, businesses, and even personal items like jewellery, artwork, and collectibles, along with debts you have like mortgages, credit cards, personal loans, and even tax debts. To work out who gets what, the courts will consider each person's financial and other contributions to the relationship, along with other factors like earning capacity and needs, to ultimately determine a percentage-based split of the property pool. When we talk about contributions, we're talking about assets and debts that each of you brought to the relationship to begin with, along with earnings and even inheritances during the relationship, along with non-financial contributions like caring for kids, housework and life admin. Once the percentage-based split is determined, it then becomes a matter of deciding how to carve up the property pool and whether individual assets or debts will be retained by one person or sold. Now, when it comes to parenting arrangements, the best interests of the child or children are front and centre. In the majority of cases, it is in the best interest of the child to maintain a meaningful relationship with both parents, and for both parents to make decisions relating to the child's care, education and health care together. Unless, of course, factors like safety, family violence, mental or physical health mean it's not in the child's best interests. So if possible, you should make every effort to work together to come up with a plan for how you will share care of the kids. When it comes to child support, there are a couple of different ways it can be approached. The first and often most preferable is to come to an agreement between the two of you that takes into account the actual expenses relating to the kids, including things like private school fees, health insurance, childcare, uniforms, and extracurricular activities. The second option is to have a child support assessment done through Services Australia. This assessment is based on each parent's income and the amount of time the child spends with each parent, but it doesn't take into account the actual and specific expenses relating to the kids. It is, however, legally enforceable. While I hope that this information is helpful, the nature of family law means that there are no hard and fast answers to how things will play out, which is why I can't stress enough how important it is to get professional legal advice from an accredited family lawyer as early on in the process as possible. You really can't afford to rely on Google or even other people's experiences for information, because every separation and set of circumstances is unique, and how the law applies to one set will be very different to how it applies to another set. Here at Lakey Law, we offer a free initial chat, so I encourage you to get in touch with our team. We have extensive experience in all aspects of divorce and separation, and wherever possible aim to help our clients come to an agreement outside of the court system.